I welcome you all to another guest lecture of the Global South Network guest lecture series. The format of today's guest lecture is slightly different from previous guest lectures. Today is more like a dialogue among the judges of Supreme Courts of different countries, for which I'm very, very grateful. Special thanks to all of the judges of Supreme Courts of different countries, including but not limited to Supreme Court of Israel, Supreme Court of Ethiopia, Supreme Court of Kenya, the Constitutional Court of Turkey, the Constitutional Court of Kyrgyzstan Republic, the Supreme Court of Ukraine, Supreme Court of Greece, Supreme Court of Mauritius, Supreme Court of Malaysia. Before I go further, it's important to explain the aim and objectives of the Global South Network. What is the scope of the Global South Network? The Global South Network is the first ever international interdisciplinary network that is by and of the Global South, serving both Global North and Global South, and that is aimed at empowering people from or focusing on the Global South. This guest lecture series is one of the initiatives of the Global South Network. The network has two major approaches, two major focuses. One is the regional focus, and the other is the disciplinary focus. Within the disciplinary groups, we have politics, international relations, law, criminology, health, well-being, and caring. When it comes to the regional approach, we have different groups, including but not limited to Latin America, Middle East, East Asia, Southeast Asia, South Asia. All of these groups together, their main aim is to bridge social, political, economic, ideological gap between of different organs of the state and people of the Global South and the Global North. And in fact, this is the main idea behind the Global South Network, that we do not look at the Global South as a concept, as an academic concept, which is discussed by political scientists, legal scholars, economists in different ways. Economists describe it in terms of middle income, low income countries, as political scientists define that as authoritarian states, hybrid states. For us, the Global South Network, it is an idea. It is a means to achieve other ends. Idea that bridge as I said, bridge different gaps between different countries, gaps such as the political gaps, social gaps, religious gaps. And it's very important given the volatile international environment we have in the Middle East, in the East Asia, in South Asia. It's very important to have people-to-people contacts. When it comes to Global South Network, it shares an interest with organizations like Association of Asian Constitutional Courts, the European Constitutional Courts Association, Association of Commonwealth Judges and Magistrates, interest in knowledge exchange and sharing good practices between judges. But we add to that interest, to that focus, the knowledge exchange and sharing good practices between civil society actors outside the judiciary, policymakers, and diplomats. Since its establishment in March 23 as a founder and convener, Global South Network, I've been working on expanding the network and moving it beyond from academic activities to and involving actors outside academia. And this included the establishment of advisory committee, introduction of different initiatives such as International Interdisciplinary PhD in Progress seminar series, which bring together PhDs, actors outside academia, lawyers community, and practitioners from different parts of the world every week. Since March 2023, we have organized around 110 activities, published 2 editorial collections, introduced 3 initiatives, including but not limited to the mentoring and coaching schemes that encourage PhD candidates from different parts of the world to apply for the PhD scholarships, and also encourage early career researchers to apply for different research projects. And that resulted in 2-3 success stories. One success story was about the PhD scholarships, and 2 stories were about the early career fellowships. Having this said, I must say that today's guest lecture is unique in sense, and I think that's one of the major queries which I receive from different parts of the world. What's the connection between global North people and the global South activities? And I think the acceptance of this invitation, arrival of our today's guest speaker, Honourable Lord Reed, President of the United Kingdom Supreme Court, fits very well within the scope of the Global South Network, within the idea of the Global South Network, that is the bridging the gaps between 2 regions. And the topic is self-explanatory: North-South cooperation, judicial cooperation between the Global South and Global Now. On behalf of the Global South Network members, lawyers, judges, academics, journalists, I warmly welcome you to the Global South Network Guest Lecture Series. It's an honor to have you during this lecture series. And I'm really looking forward to many more collaborations in the future, bilateral and multilateral collaborations. Having this said, I invite our Honourable Pro-Vice Chancellor, Head of the College of Social Science, Arts and Humanities, Professor T. S. Sanders, to come to the podium and deliver welcoming remarks on the behalf of the Honourable Vice Chancellor, University of Leicester, Professor Mishan Panaraja.
Good afternoon, everybody, and welcome to people in the room here in Leicester, colleagues and students, as well as online, internationally, across the globe. What a fantastic event for a Monday afternoon here in the UK. My name is T. S. Sanders. I'm the Pro-Vice Chancellor and Head of College of the Social Sciences and Arts and Humanities, which the School of Law sits in, and certainly takes pride of place in terms of its stature, the numbers of students and staff delivering absolutely fantastic teaching and research. A huge welcome and thank you for being here. I'm here on behalf of the Vice Chancellor, who at this point in time is in India, doing his definite thing for the Global South in terms of demonstrating our commitment to continued relationships. He is there with other colleagues from the university to launch our Centre for Digital Health and Precision Medicine with our partner Apollo in India. He apologises for not being here, but he certainly supports the event and the Global South Network. I just want to say a few words about Dr. Reayat in terms of his absolute impact on the university in his short few years of being here. You've only been here for a few years. Literally 2 years, 3 years, you were in your 3rd year possibly, and last year received the University Citizens Award, the Citizens Award, for your absolute dedication to the Global South Network and bringing people together here. I think today, and the Global South Network really does demonstrate the values of the university in terms of inclusion, impactfulness, and innovation. This series, this event today, is really about that. So thank you for your continued support and dedication to the Global South, and for just being an excellent role model to students and to colleagues alike. The series has been fantastic. Lord Reed, thank you so much, and distinguished guests online. This really should be a fantastic event. I'm going to hand over Professor Carlo Panara, our Head of the School of Law, to do a more personal introduction.
Tila. So, first of all, I would like to thank the Right Honourable President of the UK Supreme Court, Lord Reed, for being our guest today. And a welcome to the law school, welcome obviously to the University of Leicester. We're very proud and honoured to have you here today. Let me say that it is very important for us to have you here because obviously you are an inspiring figure to lawyers, especially young lawyers who study law in the law school. And of course, you are a role model for students, for staff, but also for members of the local law society. So we have the honor of having today here the president of the Leicestershire Law Society, and obviously that shows the connections between the school and the local legal professions. So it is important that these opportunities to bring together members of the judiciary and obviously members of the law school, students, staff are created. And I'm very grateful to Nauman, so I echo what Professor Sanders just said. It's very important that these opportunities are created to create role models and opportunities, but also to remove barriers. Sometimes there is the misconception that legal professions, barrister profession, but also in particular the judiciary are out of reach for many who undertake the study of law, which is very demanding, difficult. But I believe that events like this can actually contribute to remove these barriers and to remove these misconceptions. So I would just like to conclude by saying that I'm sure that you all will enjoy this guest lecture, will be inspiring. I hope that you will enjoy obviously lecturing and meeting obviously all staff and students today. I would like to thank again Nauman for creating this opportunity, but ultimately I would like to thank you again, and I'm happy now to leave the stage to the Right Honourable President of the UK Supreme Court, Lord Reed. Thank you so much.
Well, it's a great pleasure for me to give this lecture on judicial cooperation between the UK and the Global South, and to be able to engage in this way with colleagues from around the world. I'm grateful to the network and to the University of Leicester for giving me this opportunity, and to Dr. Reayat for organising and moderating the event. I'm also grateful to the many distinguished colleagues who have agreed to provide online responses. Judicial cooperation and dialogue between the UK and the Global South are not new, but they've become increasingly important in recent times. As the President of the Supreme Court, I have frequent contact with judges in the Global South and elsewhere, sometimes in order to discuss problems of common interest, and sometimes in order to provide advice or help to organise training. All of my colleagues also have contact with judges in other jurisdictions. Through these contacts, we and our counterparts in other jurisdictions are able to exchange good practices and to learn from each other's experiences and jurisprudence. Our exchanges offer new perspectives and opportunities for reflection. Our own solutions do not always appear as obvious as before. This forms part of a wider landscape of judicial cooperation between the UK judiciary as a whole and the Global South, which encompasses a range of activities and initiatives designed to foster dialogue, to build relationships, to enhance mutual learning, and to provide opportunities for judicial capacity building. This development has begun to be reflected in a growing recognition of the importance of international judicial engagements on the part of the UK government. The Foreign, Commonwealth and Development Office, for example, has increasingly supported the Supreme Court's international work, resulting in a closer relationship between the court and the department's judicial diplomacy team. And it's resulted in concrete support during some of our visits overseas, such as I received during a visit to Brazil last year, and also during some visits to the UK by judges from other jurisdictions. Recently, for example, the department provided support for visits to our court by delegations from Indonesia and Montenegro. This engagement between the UK judiciary and judges of the Global South has many different dimensions. One long-standing aspect is the need for international judicial cooperation to address disputes involving multiple jurisdictions, from the conflict of laws to the implementation of international law, from the enforcement of foreign judgments to the recognition of our own judgments in other jurisdictions. The interaction of legal systems has long presented judges with challenges. These have grown in modern times. Populations have increasingly moved beyond their borders to work and to form families, or to avoid hardship and danger. The social and economic impact of globalization, climate change, and armed conflict have made us increasingly conscious of our mutual dependence. Developments in communications and transportation have created truly global trade, where funds can be transferred from one jurisdiction to another at the click of a computer mouse, and where contracts are concluded and wrongs are committed across borders every minute using online platforms. All these factors and many others have generated an increase in the number of legal relationships which have foreign elements and have created legal challenges across our jurisdictions that require similar or at least coherent judicial responses. In this context, the UK judiciary and Supreme Court in particular have made a serious effort to engage with other jurisdictions through judicial visits, bilateral activity, and as part of multilateral organisations. This can involve welcoming visiting judges and providing programmes of activity, engaging in roundtables on legal or constitutional subjects, taking part in conferences on matters of mutual interest, and providing training in judicial skills. Our principal aim is to strengthen the rule of law globally by helping to support a robust and fair justice system and the independence of the judiciary, both in individual countries who seek our support and through international networks. In assessing the significance of these developments, I'd like to begin by saying something about the historical and cultural background. I'll then turn to a particular mechanism of engagement which has its roots in history but remains active in the present day, namely the Privy Council, a court which is based in the UK and staffed mainly by UK judges, but sits as the highest court of a number of jurisdictions in the Global South. I particularly want to draw attention both to the interchange which that institution encourages between judges and lawyers in the UK and in the Global South, and to the experience and insight which it gives British judges in relation to the legal problems of other countries at a different stage of economic development. I'll then turn to consider wider judicial cooperation and dialogue in relation to matters of substantive law. Finally, I'll consider judicial cooperation and dialogue in relation to other aspects of the courts, such as the maintenance of public confidence in the judiciary and the protection of the independence of the judiciary. My overarching theme is the role of international judicial cooperation in maintaining the rule of law and democracy around the world. Beginning then with the historical and cultural background, in the relatively recent past, we've seen a major development in international judicial relations compared with the situation when I first qualified as a lawyer over 40 years ago. But we're following in a long tradition which in Europe can be traced back to the ancient world. The relationship between the UK Supreme Court and the Global South today is influenced by important historical factors, as well as by contemporary issues and concerns. Indeed, the links between the historical and the contemporary are indissoluble. It's because of history that the UK shares the English language with many countries in the Global South. A shared language and, in consequence, a culture which in some measure is also shared. Indeed, because we in the UK now include many people whose families have come here from the Global South, our language today is influenced by the language of the Global South, particularly the Caribbean and the Indian subcontinent. Our culture is less traditional than people in other countries might imagine. It's also because of history that the UK has a shared legal tradition with many countries in the Global South. The common law, originating in England, is now, for reasons of history, the basis of many countries' legal systems. They include many countries in the Global South, such as India, Pakistan and Bangladesh, Botswana, Ghana, Kenya, Tanzania, Uganda, Malawi, Nigeria and South Africa, Malaysia and Singapore, and many other countries. Other countries in the Global South have legal systems which are based on a combination of common law and civil law sources, as in Mauritius and the Philippines. So there are a great many courts in the Global South with which our court shares a legal tradition and a method of legal reasoning, to some extent at least. In many cases, we also share with them a constitutional tradition based on a representative democracy on the Westminster model. Those of us who sit on the UK Supreme Court are conscious of this shared tradition, and we encourage the citation of judgments from other common law jurisdictions in argument before us. Judgments from some of the countries that I've mentioned, such as India, Singapore, and South Africa, are regularly cited before us. We're also aware that many courts in the Global South consider our court's judgments as a possible source of ideas and possible guidance. This is due in part to the relationships that our court has developed with the judiciary in those jurisdictions. For example, in the last year or two, we have welcomed judges to our court from such common law or mixed jurisdictions as the Bahamas, Mauritius, India, Malaysia, Brunei, Ghana, Kenya, and Nigeria. It's unsurprising if judges from those jurisdictions, which incorporate at least partly the common law method into their legal systems, may refer to our jurisprudence in their judgments. But the links between the UK and the Global South are not only historical, and they are not limited to countries with which the UK has had a historical relationship. There are strong family ties between our citizens and people living in the Global South, especially in the Indian subcontinent and the Caribbean, but increasingly also in other countries, particularly in Africa, the Middle East, and the Far East, as populations have moved across national borders. There are also strong commercial connections reflected in legal ties, as the common law is used today to govern contracts in countries where English law was never introduced by a colonial power. There are ties based on shared economic or defensive interests, often reflected in shared membership of international organizations. And there are relationships based on a mutual recognition that our different countries have a common interest in stability and in the international rule of law. Let me turn next to a particular mechanism of engagement between the UK and the Global South, which has its roots in history, but remains active in the present day, namely the Privy Council, the judges of which are normally also the judges of the UK Supreme Court. The jurisdiction of the Privy Council originated at the Norman Conquest, but its judicial work greatly expanded in the 19th century, when it became the highest court of appeal for the British Empire. Its scope has greatly diminished since then, as the colonial era came to an end, and most of the countries in the Commonwealth established their own highest courts. However, some Commonwealth countries have chosen to keep the Privy Council as their apex court, even though they have become independent. Currently, the Privy Council is the highest court of appeal for 11 independent Commonwealth countries, and for 18 overseas territories, crown dependencies, and sovereign base areas. All of the independent countries and almost all of the overseas territories are in the global south. Many of them are in the Caribbean, some are in the Indian Ocean, some are in the Pacific Ocean, others are in the South Atlantic or the Mediterranean or around the British Isles. In other words, they're all around the world. They keep us busier than you might think. Last year, we delivered almost exactly the same number of Privy Council judgments as Supreme Court judgments. Deciding these appeals requires the judges of the Privy Council to engage very closely with legal issues arising in countries belonging to the global south. We become aware of the sorts of issues which commonly arise in the societies we serve. Many of the issues are similar to those arising in the UK, such as cases involving tensions between commercial development and the protection of the environment, for example, in relation to tourism in the Caribbean or commercial fisheries in the Pacific, or cases concerned with undocumented immigration, for example, from Venezuela into Trinidad and Tobago. Some issues are of a broadly familiar kind, but they arise in a different social context. For example, questions concerning the legal recognition of same-sex relationships. Other issues are of a less familiar kind. For example, there's quite a high number of cases in the Privy Council concerned with electoral laws and the redrawing of electoral boundaries. In order to perform its role, the Privy Council needs to be accessible to the people that it serves, and it also has to engage with lawyers and judges in those jurisdictions. Since I became the President of the Supreme Court, we've tried to improve the accessibility and engagement of the Privy Council in a number of ways. First, we have for some years offered hearings online so that it's unnecessary for the parties and their lawyers to come to London. The lawyers can take part in hearings from their offices in their own countries, and their clients and interested members of the public can watch the hearings online as they're all live streamed. Secondly, we've established meetings of court users in which Privy Council judges take part, and an annual newsletter which is sent to users. Thirdly, and in my opinion most importantly, the UK government last year accepted my proposal that judges from the jurisdictions that we serve should be eligible to be appointed as members of the Privy Council so that they can sit with us on appeals. I made this proposal because it was clear to me that having the benefit of judges with direct experience of local conditions could only enhance the quality of the Privy Council's decision-making. The first such judge to be appointed was Dame Janice Pereira, formerly Chief Justice of the Eastern Caribbean Supreme Court and President of its Court of Appeal, who sat with us in December. She will be sitting with us again during this coming year, and I'm hoping that another judge will be appointed in the course of this year. More, I hope, will follow over time. Fourthly, my colleagues and I have accepted invitations to participate in events involving judges from the Privy Council jurisdictions. For example, in my case, by giving an online lecture last year at the University of the West Indies in Jamaica, which was followed by a panel discussion involving Jamaican lawyers and academics, and by taking part last year in a conference of Caribbean judges on combating financial crime. That conference provided me with the opportunity to meet or renew my acquaintance with many judges of courts in the Caribbean from which the Privy Council hears appeals, in addition to courts from other countries in the region, such as Guyana and Belize. The conference demonstrated the value of bringing together the judiciary of different countries in a region who are experiencing similar social problems and have similar legal traditions in order to share legal knowledge and experience and discuss best practice. Fifthly, we continue to accept invitations for the Privy Council to sit in the jurisdictions that it serves. These invitations are always most welcome. In my time on the court, we have sat in Mauritius, the Bahamas, and the Cayman Islands. So the Privy Council is a forum in which UK judges engage in a particularly sustained and focused way with lawyers and judges and legal systems from the Global South. But of course, our contacts and relationships with the Global South extend far beyond the Privy Council jurisdictions. So let me turn to wider judicial cooperation and dialogue, first in relation to matters of substantive law. The practical value of international legal discussions is evident when we are considering common legal problems or problems which require international solutions. To give just one illustration, many countries in the Global South are important financial centres providing sophisticated banking, corporate and legal services to international clients. Such jurisdictions are inevitably liable to attract individuals and organisations wanting to commit financial crime or to conceal the proceeds of criminal activities. Combating money laundering is important if we are to combat the drug cartels, people smugglers, and other criminal gangs who want to launder their profits or hide their gains behind an opaque screen of offshore trusts and companies. But it requires international cooperation, as the drug syndicates and people traffickers take advantage of the open borders, free markets, and technological advances of a modern world. A related problem in many countries is the use of illegally obtained funds to achieve political influence. We all know countries where organised criminal syndicates have become powerful and entrenched, penetrating political parties and undermining government and law enforcement. Corruption produces incalculable damage to governments and societies and weakens democracy and the rule of law. Like financial crime and drug and people trafficking, corruption is a phenomenon found in all countries, big and small, rich and poor. But it is in the Global South that its effects are most devastating, as it diverts funds that are needed for development and discourages inward investment. In light of this, and given the ease and speed with which the proceeds of crime can be transferred from one jurisdiction to another, courts around the world, both from the Global North and Global South, need to work together to enhance international cooperation in this field. Another illustration of the importance of judicial dialogue and cooperation is extradition, which involves states working together to transfer individuals accused or convicted of crimes from one jurisdiction to another for trial or punishment. This can be hindered by the fact that different countries have different legal traditions, and their courts may hesitate to extradite citizens for trial under another system of law. Judicial dialogue can bridge the gap by fostering mutual understanding of legal procedures, evidentiary standards, and decision-making processes. Some countries may also require technical assistance and capacity building to strengthen their legal frameworks and judicial institutions for handling extradition requests. This may include improving the rule of law, addressing corruption, and ensuring compliance with international standards. Frequent contact with judges in other jurisdictions allows us to understand better how we can assist one another to improve the efficiency of extradition in a manner that complies with robust, substantive and procedural safeguards, and can help us to address perceptions of bias or double standards in extradition processes. But the value of judicial dialogue and cooperation is not confined to addressing shared problems. In the field of commercial law, for example, where cross-border transactions are very common and are assisted by standard forms of documents, a degree of convergence of law and practice across jurisdictions is economically efficient since it reduces transaction costs. This tends to make jurisdictions sharing a common approach more attractive to each other as destinations for investment or as sources of collaboration. This is something of obvious importance to the UK as a common law country sharing a legal heritage with about a third of the world's population, and also because the common law governs about 80% of global trade. As we've said in our judgments, although it's inevitable that inconsistencies in the common law will develop between different jurisdictions, it seems to us highly desirable for those jurisdictions to learn from each other and at least to lean in favour of harmonising the development of a common law around the world. One important forum for judicial dialogue is the J20, the meeting of the most senior judges of the G20 countries, including Argentina, Brazil, China, India, Mexico, South Africa and Turkey, as well as the UK and some other countries in Western Europe, North America and Australia, together with the European Union and the African Union. Last year, I attended the most recent meeting, which took place in Brazil and focused on the role of the judiciary in relation to social inclusion and climate change, and on the challenges to the courts posed by artificial intelligence. I also take part each year in the Global Constitutionalism seminar held at Yale University. It's attended by senior judges from a number of countries from the global south, including Argentina, Brazil, Ecuador, Colombia, and Pakistan, as well as judges from Western Europe, North America, and Australasia. This group engages in stimulating and constructive discussion of current issues of importance in constitutional law, and has been a way of building international understanding of the challenges faced by judges in different parts of the world, and also of providing support to judges who face challenging circumstances. I've also taken a particular interest in helping to develop judicial capacity in countries in southeastern Europe. For that purpose, I've made a number of visits to Bosnia-Herzegovina and to Croatia, and I'm hoping to spend time later this year with judicial colleagues in Montenegro. A recent development is the use of the internet to have online meetings with foreign judges. We've held meetings in this way with the Supreme Court of Japan and the High Court of Australia, and following my meeting last year with Chief Justice Zondo of South Africa at the J20 meeting, we've recently invited his successor, Chief Justice Meyer, to hold a virtual bilateral meeting with us. The importance of judicial dialogue is also understood by many of our visitors from the global south. For example, in 2023, I welcomed the ambassador of Vietnam, who noted that trade and commercial relations between the UK and Vietnam have prospered over recent years. He spoke of Vietnam's ambitions of developing a regional financial and business centre that is attractive to both global and UK investors. I explained that commercial law may be an area where the UK can share experience, possibly through organised judicial exchanges. His visit is to be followed up by a visit this year by the Chief Justice of Vietnam. Similarly, our court welcomed a visit from the Vice Minister of Finance of Kazakhstan, who spoke of the success of the Astana International Financial Centre and International Arbitration Centre, a commercial court in that country which uses a legal code with much in common with English common law. The Minister discussed with us how the judiciary can support wider commercial policy reform across the country. Some other judicial delegations have wanted to learn about the way we manage hearings and appeals, particularly in commercial cases, including our methods of case management and our use of oral hearings. This has been a theme, for example, of our meetings with delegations from Indonesia. Another illustration is our discussions about a wide range of legal issues with judges from Ukraine. My involvement in these started in 2022, when Ukraine was granted observer status at the annual meeting of the network of presidents of Supreme Courts of the EU, of which the UK is an associate member. That gave me the opportunity to engage in discussions with the president of the Ukrainian Supreme Court. He later invited me to speak via an online link at a conference of Ukrainian judges in 2023. Later that year, the President and I took part in a roundtable discussion in London on the topic of Ukrainian courts and the justice system during a war, which was attended by a delegation of senior judges and politicians from Ukraine. In addition to discussions focused specifically on the war, Topics included capacity building of the Ukrainian judiciary, such as training programs for judges, and the implementation of digital technology in the work of the courts. It also included a discussion of institutional arrangements for the selection and appointment of judges. Last year, our court hosted a delegation from Ukraine, which included Supreme Court judges, the Minister of Justice, and the head of the Committee on Legal Policy. They were particularly interested in gaining an understanding of the UK court's practices in considering commercial disputes and how to adjudicate such cases fairly and independently. More international visits and events are, of course, in the pipeline. For example, I've been invited to give the keynote address in May this year at the Ibero-American Judicial Summit in the Dominican Republic, following a visit of the Chief Justice of the Dominican Republic to our court last year. That event brings together judges from the Spanish and Portuguese-speaking countries of Central and South America, Africa, and Europe. Other regular events for us include the Commonwealth Law Conference being held this year in Malta, and the Commonwealth Magistrates and Judges Association Conference being held in Gambia. We receive incoming visits almost every week from judges and justice ministers from around the world. For example, during November and December, we welcomed delegations from Kosovo, Montenegro, Israel, Egypt, Nigeria, Kazakhstan, South Korea, and Canada. In the past week, we have received delegations from Montenegro and Sweden. In my experience, the majority of our judicial visitors are interested in aspects of our work that do not relate to the law in a strict sense or to our judgments. They want to discuss the UK Supreme Court's approach to ensuring its independence, how it engages with the government and Parliament, its approach to communications, including with the press and on social media, and its work on transparency and on improving its accessibility and the public's understanding of its role. They're also interested in our use of technology in relation to these matters. For example, our approach to transparency and public engagement was a subject of interest to a recent visiting delegation of judges from the Constitutional Court of Bosnia-Herzegovina, who wanted to find ways to build greater trust in the courts across their community, and also to visiting judges from the Dominican Republic. We demonstrate to them how we live stream our hearings and the delivery of our judgments when we give a short explanation of a court's decision in ordinary language. We explain how we are advised about the language that we use and about other aspects of our communications with the public by a professional communications team who form part of the court's staff and include former journalists. They also liaise with the media to ensure that our judgments are accurately reported. Many judges in the Global South have informed me that they would like to see a similar approach adopted in their own jurisdictions to improve the transparency and accessibility of their courts. Other visitors to the court from the Global South, such as the Attorney General of Bhutan, who visited us in 2023, have taken a particular interest in the court's education and outreach activities, which are intended to improve the public's understanding of the court's role. Another popular topic of discussion is how the court maintains its independence, how it responds to political and media pressure, and how it engages with the world of politics. We have some experience of problems in this area, just as judges do in other countries, and discussions on this topic can assist in learning from each other's experiences and developing best practices. Many jurisdictions in the Global South are also, like the UK, interested in increasing diversity among the judiciary. They're interested in our judicial diversity and inclusion strategy and the steps that we've taken to pursue it. The final topic I'll mention is the application of technology in our court. Visiting judges often take an interest in this. For example, when the Attorney General of Bhutan visited us, he was particularly interested in the Supreme Court's live streaming and digital recordings of previous hearings, which I mentioned earlier, and also our online educational programs, including programs for schools and universities. Many of our discussions nowadays also concern the use of artificial intelligence, which we are beginning to introduce in a cautious way. To conclude, it's evident from the UK's cooperation and dialogue with the Global South that a commitment to justice and the rule of law is a shared priority of judges around the world. As judges, it is our vocation to give people a reason to believe that justice is possible. We have a duty to do our best to make justice happen every day and to try to make the world more just for all of our citizens. Justice and the rule of law are also goals which many people outside the law understand are important to economic prosperity and to personal security. At the same time, judicial independence and the rule of law are under pressure in much of the world. In this context, by addressing shared challenges and promoting equitable partnerships, judicial contact can enhance understanding and cooperation between the global North and the global South. That can only contribute to global justice and security. Thank you very much for listening to me.
Thank you very much. Thank you, Honourable Lord Reed, President of the UK Supreme Court, for delivering a very insightful guest talk on judicial cooperation between the United Kingdom and the Global South. Now I open the floor to online responses from judges of different countries. And first in number is the Right Honourable Dr. Siri Asna Binti Datu Muhammad Hashim, Chief Judge of Malaya, on behalf of the Right Honourable Chief Justice of Malaysia, Tun Tengku Mun Binti Tuan Mat.
Thank you very much. Good afternoon, the Right Honourable Lord Robert Reed of Allermuir, President of the UK Supreme Court. First and foremost, I would like to convey apologies, warm wishes from the Chief Justice of Malaysia. Due to a prior commitment, she is unable to attend this dialogue. I would like to take this opportunity to express my gratitude to the Global South Network and the University of Leicester for inviting the Malaysian judiciary to participate in this dialogue. The Malaysian judiciary recognizes the importance of judicial cooperation and dialogue as a cornerstone for strengthening the rule of law and addressing complex legal challenges. To this end, the Malaysian judiciary has actively participated in and welcomed contribution from other jurisdictions, Commonwealth and non-Commonwealth countries, both regionally and globally, through programs aimed at enhancing the development of the judicial system in Malaysia. Our focus is on exchanging best practices, experiences, and judicial approaches to address emerging global challenges, including multi-jurisdictional dispute, cross-border crime, and technological advancements such as AI. In Malaysia, we have the Judicial Academy, which was established in 2012, and this Judicial Academy is the training institute for superior court judges to equip superior court judges with the skills and knowledge necessary to perform their roles to the highest of professional standards. I was the former chairman of the training committee before I was appointed as the Chief Judge of Malaya, and I'm proud to say that on the whole, the training programs organized by the training arm of the Judicial Academy has succeeded in increasing or enhancing the knowledge and understanding of Malaysian judges in the interpretation of laws and as well as strengthening the quality of judging. The training programs offered by our Judicial Academy fall into two categories. One, in-house training sessions, and collaborative program with external bodies, both local and foreign, to conduct the workshop and talks in specialized areas of law. At the end, sometime in November 2023, the Malaysian judiciary, led by the Right Honourable Chief Justice of Malaysia, was invited by UK Judicial College for a working visit to the Supreme Court of the United Kingdom and the Judiciary of England and Wales. Following that meeting, the Malaysian judiciary was also invited to send judges to a course on judge craft. Although we were unable to attend due to some reasons that was unavoidable, we believe that this initiative has opened promising opportunities for our judges to pursue continuous professional development in collaboration with the UK Judicial College. At our annual Judges Conference, which will be in February of this year, His Honour Judge Martin Picton, who is the Director of International Training at the Judicial College, will deliver a talk on judicial personal resilience as part of our ongoing judicial cooperation efforts. We look forward to the continued engagement with the UK judiciary and other international partners. By working together, we aim to improve the administration of justice and develop a judicial system that only upholds the rule of law, but is also effective and accessible in meeting the demands of a changing world. Thank you very much.
Thank you very much, the Right Honourable Dr. Sri Hasnan Binti Dr. Mohammad Hashim, Chief Judge of Malaya. Now I invite Honourable Justice Zildosheva Lunara Chatkalbikovna, the Constitutional Court of Kyrgyz Republic. Please share her thoughts.
Thank you. Good evening. It's 9 p.m. in Kyrgyz Republic. Dear colleagues and participants of the public lecture, dear Dr. Nauman Reayat, first of all, let me express my sincere gratitude to you as the founder of Global South Network for organizing Lord Reed's lecture, which provided a valuable platform for constructive judicial dialogue. Dear Lord Reed, thank you for a very interesting lecture on such an important topics and as judicial cooperation between the United Kingdom and the Global South. Your lecture has greatly enhanced our understanding of the opportunities and challenges in fostering global judicial cooperation. The challenges facing judicial systems today are increasingly complex and multifaceted. The protection of digital rights, justice in relation to climate change, minority rights, all these topics require the combined efforts of different countries and legal systems. We need to develop mechanisms to effectively address these issues through international cooperation, exchange of experience, and the development of common standards. In this regard, the Constitutional Court of the Kyrgyz Republic is actively developing international cooperation in several important areas. As a member of the Association of Asian Constitutional Courts and equivalent institutes, the Constitutional Court of the Kyrgyz Republic cooperates with judicial bodies throughout Asia to promote the principle of the constitutionalism, democracy, and the rule of law. This association provides a forum for judges to share best practice, engage in joint research activities, and participate in training programs aimed at enhancing judicial expertise in constitutional matters. The AACC commitment to fostering regional cooperation strengthens our ability to address constitutional issues in a globalized world. Our memberships in the Eurasian Association of Constitutional Review Bodies is particularly important to us. This association allows us to work together to improve mechanisms for protecting human rights and strengthening the legal system in the face of modern challenges. Working within the framework of this association, we strive to make international justice more effective, inclusive, and accessible to everyone. Another important step towards strengthening international judicial cooperation is Kyrgyzstan's participants in the Conference of Constitutional Jurisdictions of the Islamic World. This participation has inherited our understanding of how to balance traditional values and modern legal principles, which is key in the context of globalization and cultural exchange. In this context, we are also actively studying the experience of our other countries facing similar challenges and utilizing their best practice to improve our own judicial system. It should also be emphasized that the Kyrgyz Republic is a full member of the European Commission for Democracy through law, which is also known as the Venice Commissions. This membership provides us with important opportunities to actively participate in shaping modern standards of constitutional justice and judicial practice. The Venice Commission's assist is not only in matters of constitutional reforms, but also in developing legislative initiatives aimed at protecting human rights and developing democratic institutions. The Global South Network opened new horizons for judicial cooperation. We see great potential in several key areas. First of all, it is the development of digital justice. The introduction of modern technologies into court proceedings helps to make process for accessible and efficient, improve interaction between courts in different countries and ensure a higher degree of fairness for all participants in the process. Moreover, sharing experience on how to protect constitutional rights in the context of digitalization with technology and is increasingly influencing of our daily lives have become a critical topic for international discussions. In addition, an important step is the development of joint educational programs for judges for strengthening professional ties and share experience at a variety of levels. Judicial continuing education programs that focus on current issues of constitutional law, judicial ethics, and the application of international legal standards are becoming a necessity for judicial system seeking to improve. Equally important is the development of mechanisms to protect environmental rights and climate justice, which are integral to sustainable development and securing the future for generations to come. In this context, the Global South Network also offers unique opportunities to develop international standards for environmental protection and climate change. The Constitutional Court of the Kyrgyz Republic is always ready to share its experience in the field of constitutional justice, especially in the context of transformation of the legal system with colleagues around the world. We are also actively interested in studying best practice that other countries are applying in order to innovate in justice and create a fair, more inclusive and efficient judicial system. We sincerely believe that strengthening cooperation between the judicial system of the North and South is key to creating a fair and effective global rule of law. Lord Reed's speech clearly demonstrated the importance of such collaboration, and I look forward to continued productive cooperation. Thank you for your attention.
Thank you very much. Thank you, Honourable Justice Dr. Lunara Chatkalkovna, this Constitutional Court of Kyrgyz Republic, for responding to the Honourable Lord Reed's talk. Honourable, now I invite Honourable Justice Dr. Azmirul Zahid, the Supreme Court of the Maldives.
Good afternoon. First of all, I would like to extend my sincere gratitude to Dr. Nauman Reayat, founder of the Global South Network and the University of Leicester, for providing me with the opportunity to react to the insightful talk by Lord Reed. I would also like to sincerely thank Lord Reed for his enlightening and interesting talk. It is an honor and privilege to offer a few reflections on this crucial subject, particularly from the perspective of a small island nation like the Maldives. Lord Reed emphasizes the importance of judicial cooperation in addressing global challenges that transcend borders. I believe these challenges include judicial independence, fundamental rights protection, climate justice, and transnational crime. The need for collaboration between the global North and the global South is more pressing than ever. North-South judicial cooperation resonates deeply with us in the Maldives, a nation uniquely positioned at the intersection of vulnerabilities and opportunities. For those unfamiliar with the Maldives, our judicial system comprises a three-tier structure: the Supreme Court, the High Court, and the First Instance Superior and Lower Courts, which are scattered over 180 islands. The Supreme Court serves as the final authority on the interpretation of the Constitution, the law, or any other matter dealt with by a court of law. The Supreme Court has original jurisdiction in matters such as parliamentary disqualification, presidential elections or removal, and states of emergency. It also holds inherent jurisdiction over disputes which may result in a constitutional void in the country, disputes between two powers of the state over the interpretation of the Constitution, and public interest constitutional issues. Additionally, the court has advisory jurisdiction where Parliament may request its opinions on significant legal or constitutional questions. While the Maldives follows a legal system significantly influenced by common law, the insights shared by courts in the global North, including the UK Supreme Court, have often provided guidance in areas such as constitutional interpretation, human rights, and trade-related laws. When interpreting fundamental rights, our Constitution stipulates that our interpretations are aligned with best practices of democratic nations. This demonstrates how cross-jurisdictional exchanges can enrich and strengthen our domestic jurisprudence. The Maldives judiciary exhibits success stories from global North partnerships and collaborations. I would like to highlight the long-standing relationship between the Maldivian judiciary and the UK. I would like to express my heartfelt gratitude to the UK government for the various partnerships with our judiciary in strengthening family justice, civil justice, and criminal justice by assisting us in the development of policies and procedures. Professional development programs for judges and employees of the judiciary, need-based effort on digitalization, public outreach programs, and women in judiciary are just a few projects supported by the UK government. Ongoing projects include working with the criminal justice system, including judicial mentoring that will bring meaningful outcomes by addressing emerging challenges. Judges from the UK made significant contributions in some of these projects. For courts in the global South, including those in the Maldives, such exchanges are invaluable. Capacity building initiatives, judicial training programs, and collaborative analysis of case law can address resource disparities and enhance access to global legal resources. Equally, it is crucial for the global North to acknowledge and learn from the local knowledge and traditions of the global South, enriching global legal discourse. Achieving this requires constitutional and Supreme Courts to identify shared goals and areas of mutual interest, prioritize them, and establish partnership for cooperation. While I appreciate the fact that the UK judiciary is actively engaged in collaborations with other judiciaries from around the world, areas for judicial collaboration between the global North and South are endless. Research and development could be focused as an area of cooperation between courts of the global North and South, as this shapes all other areas of collaboration. Courts can strengthen judicial capacity, enhance knowledge sharing, and address shared challenges. They can jointly conduct research on key issues like judicial independence, case backlog reduction, and access to justice, publishing collaborative reports that reflect shared insights. Regular interaction between judicial academies, participation in international forums, and mentorship programs can facilitate capacity building and skill development. Collaborative initiatives may also include internships and academic exchanges for judicial clerks and law students, fostering global legal exposure. Additionally, providing technical assistance, e-learning platforms, and access to legal databases supports judicial education, particularly in the Global South, enhancing the overall effectiveness of justice systems. Judicial cooperation must respect the autonomy and diversity of legal systems. For countries like the Maldives, preserving our unique legal identity is essential while engaging in collaborative efforts. Mutual respect and a shared commitment to justice are key to successful cooperation. In conclusion, Lord Reed's talk highlights the significant opportunities judicial cooperation offers in addressing shared challenges and promoting global justice. The Global South Network could provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape through continued engagement between the global North and South. Thank you.
Thank you very much. Thank you very much, Honourable Justice Dr. Zaya, the Supreme Court of the Maldives, for your response. I must say she is severely ill and still she is able to deliver the response. Is commendable. I invite Honourable Justice Nirua Azam Puzni Judge, the Supreme Court of Mauritius, to deliver his response.
So, my lord, I concur with your speech in its entirety, but I guess I cannot start and end my response by merely stating this. So, first of all, I'm very humbled and at the same time honored to have been invited by Dr. Nauman to react to Lord Reed's lecture today. I extend my gratitude to Dr. Nauman for this opportunity. All of us can only sincerely hope that the GSN network continues to expand its areas of activity, further strengthening its impact and reach. Lord Reed has outlined the essential and relevant aspects of the already existing judicial cooperation between the UK and the Global South. And it was very inspiring to hear that the UK continues to help and act as a torch bearer for the Global South in matters of judiciary. We can only benefit from the very long and rich experience of the UK judiciary and its legal jurisprudence. The UK and Mauritius has a very strong judicial cooperation, the main reason being that Mauritius still retains the constitutional rights of its citizens to appeal to the JCPC. Hence, the JCPC is the highest court of appeal of Mauritius. We have largely benefited from the very rich binding precedents from the JCPC, which has a deep and decisive effect on our judicial reasoning in our everyday judicial work. This constitutional right to appeal to JCPC gives Mauritian public, as well as would-be foreign investors, a sense of confidence in our judicial system. Having the JCPC as the apex court of Mauritius no doubt strengthens rule of law and acts as a powerful check and balance to the judicial system in Mauritius in terms of judicial accountability from a completely independent and impartial source far from the shores of Mauritius. This judicial cooperation can no doubt be further enhanced. For instance, the JCPC may be composed of one local judge whenever hearing a case from Mauritius. And here I can only thank Lord Reed, who has been the architect in successfully convincing the UK government to allow justices from across its jurisdiction to sit as part of the panel. An immediate consequence of this very welcoming initiative by Lord Reed is that the local judge will bring his or her local expertise as well as share the local knowledge and conditions, which will only help develop a better judicial cooperation in the judicial decision-making process and enhance the judgment of the JCPC. Another effect of this reform is to address the argument that allowing the JCPC to decide on local cases amount to a compromise of sovereignty, with one of its local judges forming part of the panel deciding cases from its jurisdiction This argument would hopefully have no effect whatsoever. On another note, it is no secret to anyone that the legal cost to appeal to the Privy Council is very high and very often acts as a barrier to a litigant to explore the avenues of appeal, even if his case is very strong. Reviewing the legal cost related to appeal to JCPC could be seen as a big step forward towards making equal access to justice for all a better reality. Nonetheless, it is only fair to say that there is already a very healthy judicial cooperation between the United Kingdom and Mauritius. As regards the present topic, Lord Reed has extensively highlighted the importance of judicial cooperation in relation to matters of substantive law. I would like to emphasize on another area, that is the perception of judicial system today and new challenges facing judiciary around the world. There is a wide perception indeed, which is growing, and a reality already in some jurisdictions, that there is a lack of public trust in the judicial system. It is fair to say that this is a world phenomenon affecting both the North and the South. The obvious reasons are the following. First, administration of court has been saturated since a long time and needs fresh air. Complaints of backlogs in case hearing and its outcome has become a common feature. Inefficient procedures leading to exceedingly long proceedings, poor management practices, lack of communication skill of the judiciary, amongst others, have long been at the forefront of criticism against the judiciary in most parts of the world. Second, there is an ever-growing worry that the independence of the court system is being gradually eroded due to political interference and corruption, or at least a very strong perception that this is the case, together with a lack of transparency and accountability. Third, it is becoming a constant complaint that access to justice is being denied, particularly to the most vulnerable groups of the society, such as the minority groups and the very poor. There are no doubt other problems, for example, the mode of appointment of judges and related security of tenure, which has an incidence on the independence of judiciary. Another disturbing reality in the performance of duty of a judge today is his personal security. Not so long ago, a magistrate was shot whilst in court by a police officer in Kenya, whereas only yesterday, you surely must have heard of 2 Supreme Court judges in Iran shot dead inside the court premises. It is in this particular context, I believe, judicial cooperation between North and South becomes crucial, since, as Lord Reed has emphasized in his speech, a commitment to justice and the rule of law is a shared priority of judges around the world. And sharing knowledge and experience amongst the judicial actors of the North and South becomes a relevant aid to strengthen the rule of law throughout the world and establish the best practice. This is, I believe, the true aim of judicial cooperation, so that the new difficulties which the judicial system is facing may be resolved. Surely there must be jurisdictions which have already tackled some of the problems highlighted earlier, and therefore their experience would be a valuable guidance to other jurisdictions which are facing the same evils in their judicial system today. To conclude, I can only reiterate my pleasure to have heard Lord Reed highlighting how the UK judiciary has been helping the other jurisdiction in various areas of concern. Such judicial help can only be welcomed, so that there is a better future for the judiciary everywhere in the global North and the global South, or rather, should I say, the global village. I thank you for your attention.
Thank you very much, Honourable Justice Niru Azam, Personal Judge, the Supreme Court of Mauritius, for your response. Now I invite Honourable Justice Martha Koon, the first female Chief Justice and the President of the Supreme Court of Kenya.
Thank you very much. Good evening. It is 6:30 p.m. here in Kenya, in Nairobi. And I also wish to join the other speakers to congratulate Lord Reed for that very thought-provoking lecture. I also want to agree with the colleagues who have spoken that we have a joint responsibility to ensure that we secure the independence of the judiciaries. We ensure there is access to justice for all, and especially the vulnerable, women, children, and the poor. We must also explore the connection between the common law, which we inherited from Britain here in Kenya, and the traditional justice system that is practiced largely by the communities, but there is no linkage between the traditional justice and what is modern justice. Something we are exploring here in Kenya through a program called Alternative Justice System, Court Annex Mediation. We are training communities to resolve disputes by themselves, so long as they follow the principles of fair trial and other constitutional principles. If they bring those agreements, we adopt them and make them the order of the courts. So I really appreciate the President of the Supreme Court of the United Kingdom, the Right Honourable Lord Reed, for the seminal and thought-provoking lecture that has shed light on important issues and also encourages us to think deeply about access to justice and the judicial cooperation between the United Kingdom and the Global South. I think we face the same problems of cross-border breaches of law, money laundering, human trafficking, and all that. So we have to speak the same language when we talk about defending the rule of law and ensuring our judiciaries are accessible to resolve all the disputes. The relationship between the judiciaries in the Global South and in the UK is anchored on deep historical ties, shared legal traditions, and commitment to enhancement of justice within our countries and across the globe. As they say, injustice in one country spreads to the next country and to the next. So we must worry what is happening with our neighbors. Even if we are safe and secure in one judiciary or in one country, we must worry whether our neighbor is safe and secure. So judicial cooperation between the UK and the countries in the Global South has the potential to address contemporary challenges, improve judicial practices, and promote the rule of law at the domestic and global level. We in Kenya, the Kenyan judiciary, in our blueprint, which we call the social transformation through access to justice, we appreciate that effective execution of judicial function requires cooperation with other judiciaries on a continental and global scale. This entails judicial exchanges like this one, conferences, and cooperative endeavors that enhance exchange of best practices and insights from regional and international experiences. I was so happy to listen to the speech by my colleague from Mauritius because he talked about the challenges we all face including the insecurity of judges and magistrates when they are executing their duties, the lack of infrastructure, the lack of budgetary allocation that can enable a judiciary employ the workforce they require of judges, magistrates, and judiciary staff to execute the mandate. I believe that based on our common interest in advancing the rule of law and protection of fundamental rights, we can forge a strong affiliation between the judiciaries in the Global South and the United Kingdom. Through such cooperation, we can share experiences. We can also set common goals. We can also deal with the challenges and seek potential solutions related to upholding judicial independence, enhancement of collegiality among judges, and strengthen peer-to-peer learning. The cooperation between the judiciaries in the Global South and United Kingdom can serve as an invaluable platform for advancement of access to justice, protection and promotion of the rule of law and constitutionalism, and judicial excellence across our regions and globally. I thank you for inviting me and for your attention. Thank you very much.
Thank you very much, Honourable Justice Martha Koome, the Chief Justice and the President of the Supreme Court of Kenya, for your response. Now I invite Honourable Justice Tewodros Meherit Kebede, the Chief Justice and the President of the Federal Supreme Court of Ethiopia.
Good afternoon, everybody. Thank you, Dr. Nauman, for the invitation extended to me. I am pleased to be part of this lecture series, and I appreciate Honourable Lord Reed for his informative and interesting lecture. Universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal. That is why almost all speakers reiterated the need for cooperation. The Honourable Lord Reed raised several interesting matters in the lecture, which require a lengthy discussion. However, I have to be brief as I have only a few minutes, hoping that a forum will be available for a deep dive sometime in the future. I will have comments to make on matters covered by the lecture, with particular emphasis on language and technology. What has been said about the relevance of a shared language, which I fully agree. But the paradox we face in Ethiopia may help you to look at it from a different perspective. Ethiopia belongs to the civil law tradition, while English is the foreign language that we use. For instance, laws are issued both in a local and English language in the official gazette. Generally, lawmaking, its communication and interpretation, and resolution of disputes depend on language. Because of use of the English language, more and more common law concepts are making it to our laws. So, language in law is not a mere communication tool, but it is a means of carrying across the concepts and thoughts in a legal tradition. Ours is an instance of language in use without a shared culture, both in terms of history and legal tradition. Our legal tradition is significantly influenced by the civil law tradition, even if the influence of common law is evident as well. This is more so in the lawmaking, which benefits from the experience of other jurisdictions. The judiciary is more isolated in this regard. We have no practice of relying on judgments of other jurisdictions, which I believe must change. In the recent decision of the Cassation Division of the Federal Supreme Court of Ethiopia, an attempt was made to cite decisions of courts of the UK, India, and USA, which is a new beginning. This is particularly pertinent on matters relating to civil procedure, which was basically borrowed from the common law legal system. However, we find legal concepts which made it to our law through transplantation, and it is not easy to grasp their meanings without understanding their application in the source jurisdiction. As the Honourable Lord Reed stated in his lecture, this should be encouraged, though here also language is a barrier, as in our case, local language is used in the administration of justice. Courts have been employing technology for a long period of time, and it is believed that it enhances access, improves efficiency, reduces cost of court proceedings, to mention some of the benefits. It is even transforming the role of judges for now, the possibility of replacement of judges being a topic of discussion, which was unthinkable some years back. With artificial intelligence becoming more and more in use, technology is more of a mere tool of improving efficiency or access. Embracing technology is becoming more consequential, and I appreciate your take on this, taking into account the pace of using technology. I agree with the need for international dialogue, which cannot be emphasized enough because of the fact that the border between civil law and common law traditions is becoming more and more blurred, not to mention the reasons already stated in the lecture. It is timely to explore such discussion beyond the legal traditions and consequences of historical events for better and broader engagement. It is essential to have such cooperation so that we learn from the best practices, challenges and achievements of each other for prevalence of rule of law, robust judiciary, and ultimately a better world. I take this opportunity to express our wish to have cooperation with the UK judiciary in the areas of rule of law, judicial independence, capacity building, and experience sharing. Thank you for your attention.
Thank you very much, Honourable Justice Tewodros Mehret-Gebrevigi, Chief Justice and the President of the Federal Supreme Court of Ethiopia, for your response. I'm going to invite Honourable Judge Mr. Christos Touchanis, Vice President of the Hellenic Council of State, Supreme Administrative Court, Greece.
Thank you very much for the invitation. Listening to the introduction, the report, of the beginning to the initial report, I have to extend my heartfelt congratulations, well-deserved, for the hectic activities you have made. I am astonished, I am amazed, I have to congratulate you. Well, I am very unfamiliar with the activities of the network, and I was impressed. Now, as far as we are concerned, we are the Greek Council of State, which is one of the Supreme Administrative Courts of Greece. We don't have to linger on the third one, but I have to mention the other main Supreme jurisdiction, which is the one for civil and criminal cases. We focus on the administrative cases, which means those who from where arise the majority of the constitutional matters. So we are, to a certain extent, a constitutional court too. We always have been rather open to the international cooperation. So the Council of State is a founding member of the International Association of Supreme Administrative Jurisdiction. And since Greece's accession to the European Union, we are also part of the Association of the Council of State and Supreme Administrative Jurisdictions of the European Union, which has the title ACA Europe, hereafter ACA Europe. ACA Europe is a European association composed of the Courts of Justice of the European Union as well as of the Councils of State and the supreme administrative jurisdictions of each of the members of the European Union. We have many jurisdictions with the status of observer, such as Albania, Montenegro, Serbia, and Turkey, while other countries as Norway, Switzerland, and the United Kingdom are invited to participate in the activities of the association as guests. Thus, ACA Europe is a unique network of supreme administrative jurisdictions that extends across 34 European states. The objectives of the ACA Europe remind me largely of the ones of the United Kingdom Global South Network, and they are namely to obtain a better understanding of law by the judges of the Supreme Administrative Courts across Europe and a better knowledge of the functioning of the other Supreme Administrative Courts in the implementation of the law, to improve the mutual trust between judges of the Supreme Administrative Courts, to foster an effectively and efficiently functioning of administrative justice in the European Union, to provide exchange of ideas on the rule of law in the administrative judicial systems, and finally to ensure access to the decisions of the Supreme Administrative Courts implementing EU law. Every 2 years, a Supreme Administrative Court of a member state of the European Union takes over the presidency of the ACA Europe. I'm proud to say that the Greek Council of State has taken over the presidency of ACA for the 2-year period of 2025 to 2027, and has the obligation to organize 3 seminars within the Greek territory. How those seminars are organized, and that could be perhaps it could be a source of inspiration for other international networks. Well, the organizing jurisdiction drafts a questionnaire pertaining to various aspects of the topic chosen, and then the other members' jurisdiction answer the questionnaire, and then the organizing jurisdiction makes a synthesis of the answers given by each and every participating court. The latest seminar of ACA Europe under the Finnish and Swedish joint presidency was held on November 20 to 24 in Versailles, France, and the theme was ethics and the recruitment of members of the Supreme Administrative Courts and Councils of State. The International Association of Supreme Administrative Jurisdictions currently comprises 62 members. Membership is open to any court having standing to give final judgment in disputes arising out of administrative activities. Courts may also have a status of observer. They may attend the association's events, but they do not take part in the meetings of the statutory bodies or in the magistrates' exchange program. 2 words about the magistrates' exchange program. There is a program in the framework of which every country, the country who are eager to offer a place for the exchange, can host another member from another jurisdiction from a period of time of 1 or 2 weeks. The visitor is welcome to every activity of the court concerned, and then they draft a report and what they see, which were their impressions, etc., and vice versa. And this is a very useful report, and we learned many things from one another's experience. The Council of State is a member of the board of the International Association. The latest seminar was held in 2023 in Ankara, Turkey, on the theme Judicial Review of the Acts of Independent Administrative Authorities. The Council of State, our Council of State here in Greece, also participates to the Commission of Venice, the Council of Europe's advisory body on constitutional matters. Last but not least, the Council of State places great importance on creating bonds with foreign Supreme Courts with the aim to exchange information and to enrich the judicial experience all over the world. And of course, those bonds take very usually the form of bilateral exchanges. We have had recently such exchanges with jurisdictions of Albania and other countries, and sometimes in the past even with the countries of Asia. So that was a description of the way the Council of State deals with international, is involved in international cooperation. I think we can exchange experience about how international judicial cooperation can take place, what forms can it take. Once more, I would like to thank you for the invitation, to wish you well in pursuing your activities, and I hope this contact will go on in the future. Thank you very much.
Thank you. Thank you, Honourable Judge Mr. Christos Chanis, Vice President of the Hellenic Council of State, Supreme Administrative Court, Greece, for your response. Indeed, the contact will go beyond, and this is what I'm going to touch upon in my concluding remarks. I now invite Honourable Judge Doctor of Law, Professor Vitaly Gurkovich, Secretary of the Grand Chamber of the Supreme Court of Ukraine, to share his response.
Thank you so much for invitation. Thank you to Mr. President Lord Reed for such interesting speech, and it made me following responses. First of all, for all Ukrainian judiciary, the United Kingdom Supreme Court approach to the ensuring of the courts and judges' independence is extremely important. It is obviously that an independent judicial system is a guarantor of justice and human rights. Courts must be protected from pressure by other branches of power, political forces, and private interests. For Ukrainian courts, one of their priority goals is building a proper communication with the society. Transparency and accountability of judges is key to building citizens' trust to the judiciary. Actually, I may say that now Ukrainian Supreme Court is developing a communication strategy in which a lot of issues must be established, including the ways of communication with the society, of individual judges, and as well as the communication on behalf of the court. I believe that this work will have the result of increasing transparency of national judicial system and improving the public's understanding of its role. As far as concerns the cooperation between different countries in relations of matters of substantive law, which was mentioned in the Lord Reed's speech, I must say that Ukrainian legal system now has features of mixed jurisdiction. I mean that more than 70 years, the socialistic legal system was built. Till 1991, Ukraine was a part of the previous Soviet Union, but now we have legal instruments from a different legal system. For example, in accordance with the national legislation, Ukrainian courts apply the case law of the European Court of Human Rights as a source of law when considering cases. Also, conclusions of the application of the legal rules made by the Supreme Court must be taken into account by all Ukrainian courts when applying such legal rules. Now, it's very important for Ukrainian judiciary to become a part of the judicial system of the European Union. That is why it is especially remarkable that Ukraine was granted an observer status at the annual meeting of the network of the presidents of the Supreme Court of EU in 2022. Actually, right at the beginning of this year, on February 24, a full-scale invasion was launched by the aggressor state, the Russian Federation. The war affected every Ukrainian, all areas of our life, caused a wave of internal and external migration. The property damage caused by the Russian Federation as a result of hostilities to the population and businesses is estimated more than 500 billion euros. The damage to the environment is about 71 billion euros. So Ukrainian courts faced a lot of difficult legal issues related to the war in Ukraine, but the most important of it concerns bringing the aggressor state to the liability. On April 2022, the Supreme Court held that after beginning of the war in Ukraine in 2014, the Court of Ukraine, considering a case when the Russian Federation is the defendant, has the right to ignore the judicial immunity of this country and consider cases on compensation. Maintaining of the judicial immunity of the Russian Federation will deprive the plaintiff's right to a fair trial under the Article 6 of the European Convention of the Human Rights. I hope that courts of different countries will agree with such approach to the judicial immunity of the aggressor state in the procedure of the enforcement of Ukrainian courts' judgments about collection damage caused by the war. Finally, I think that the importance of such events like now lies in the fact that they allow to bring together professionals from different countries to share experiences and jointly search for solution. In today's words, where borders between countries are increasingly blurred, only cooperation and dialogue can ensure effective justice and protection of the interests of each person. I really believe that joint work for building a just society is not only an opportunity, but also our responsibility. Thank you for your attention.
Thank you very much, Honourable Judge Doctor of Law, Professor Vitaly Yurkovich, Secretary of the Grand Chamber of the Supreme Court of Ukraine, for your response. Now I invite Honourable Justice Stephen Al-Majid, the Constitutional Court of South Africa, to deliver his response. Justice
Good
Stephen.
afternoon, Dr. Nauman Reayat and Lord Reed and other honourable colleagues. It is an honour and a privilege to be here. And may I at the outset commend you, Dr. Reayat, for the immense work that you're doing within the GSN and the Global South Network. It is a much admired initiative which we fully support, as you know. Also to Lord Reed for a very insightful presentation, and it is remarkable the amount of work that the UK Supreme Court is doing in assisting other courts. And much has been said already in response, and I'm not going to repeat that given the time limit. As Lord Reed has alluded to, we have a relationship already between our apex court, the Constitutional Court, and the UK apex court, the Supreme Court, initiated by former Chief Justice Raymond Zondo and Lord Reed at the J20 in Brazil. And of course, this year, the G20 and also then the J20 is coming to South Africa. And we propose continuing that relationship within the J20. But also, more importantly, there is a virtual meeting scheduled between the present Chief Justice Maya and Lord Reed within the foreseeable future. And so South Africa and the UK have many commonalities in our legal system. Of course, our common law comes from the UK and also from Roman Dutch law, and our procedural law emanates from English law. And so we have built this relationship, and Lord Reed has correctly emphasized the absolute imperative that as the world becomes a global village, we need judicial cooperation without fail, unhesitatingly and unreservedly. He has mentioned many areas. I'd like to highlight just three. One is extradition, and if I may say tongue-in-cheek, many UK offenders appear to find their way to South African shores, more particularly Cape Town, and we have had several extradition requests from the UK in South Africa. But also, more importantly, one of the challenges that I see in the foreseeable future, challenging all of us, regardless of where we are located, is this boundaryless offenses of cybercrime. And jurisdiction is a very serious challenge in cybercrime matters, and this is where we need judicial cooperation as is entrenched in the Budapest Convention. Also, I'd like to highlight a further area of the law where we need judicial cooperation would be Hague Convention matters. And our court too have been seized. All our courts, but particularly our court has been seized with Hague Convention matters where we needed judicial cooperation. And of course, international crime syndicates are getting more and more efficient and more and more brazen, and it knows no boundaries. And therefore, I welcome this initiative. And again, I'd like to reiterate that it is a wonderful surprise to hear what the UK is doing to assist other jurisdictions. And we in South Africa look forward to this continued relationship, not only within the J20 this year in South Africa, but also in fora like these. And let me conclude by thanking Dr. Nauman Reayat for this opportunity and for this wonderful initiative in bringing all of us together in a forum like this. Thank you.
Thank you, Honourable Justice Stephen Al-Majid, the Constitutional Court of South Africa, for your response. Now I invite Honourable Judge Mirsad Iman, the Constitutional Court of Bosnia and Herzegovina.
I'm grateful to Dr. Reayat, the founder of the Global South Network, for inviting me to respond to this important talk. Your dedication and commitment to advancing global judicial cooperation through this network is commendable. It is an honor and privilege to participate in such an important event. I sincerely thank the Right Honourable Lord Reed for delivering such an insightful and thought-provoking talk. Your perspectives on fostering cooperation inspire us to further strengthen these connections. And I thank Lord Reed for his commitment to advancing global judicial cooperation. The Constitutional Court system in Bosnia was established in the 1960s. Last year was the 60th anniversary of the Constitutional Court of Bosnia and Herzegovina. In the post-Dayton period, and the Constitution of Bosnia is Annex 4 of the General Framework Agreement for Peace in Bosnia and Herzegovina. So the Constitutional Court, starting from 1997, has maintained strong cooperation on the international level with constitutional courts and other highest national courts exercising constitutional jurisdiction, as well as other institutions worldwide. This includes broad bilateral and regional collaboration with the countries in the region. We also cooperate with the European Court of Human Rights, the Venice Commission, the Conference of European Constitutional Courts, the World Conference on Constitutional Justice, etc. The Court promotes its case law and doctrine through participation in international conferences and bilateral initiatives, contributing to the European legal framework and being inspired by it. As a member of the Conference of European Constitutional Courts since 2000 and the World Conference of Constitutional Justice since 2013, our court has actively engaged in broad international dialogue. Its cooperation with the Venice Commission includes sharing decisions, case law, legal information, and obtaining advisory opinions. Regionally, our court initiated a cooperative effort in 2003 among constitutional courts of the former Socialist Federal Republic of Yugoslavia countries, focusing on transitional judicial systems, human rights, and the rule of law. This successful initiative began in 2004 with a roundtable in Sarajevo, the capital of Bosnia and the seat of the court. And it is still active. Since 2017, the court has partnered with the Advice on Digital Rights in Europe, the AIR Centre in London, UK. However, as heard from talk given by Right Honourable Lord Reed, most of the initiatives, as well as similar efforts in the Middle East and Asia, primarily focus on superior courts and specific regions of the world. In my opinion, there remains significant potential for growth and development in the area of North-South and South-South judicial cooperation. The Global South Network stands out as an excellent initiative in this regard, as it focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc. It serves as a one-stop platform connecting various courts, nationalities, and societal groups. In this context, we strongly recommend that the network establish a permanent group involving superior courts from around the world within its structure. Our court is open to judicial cooperation in different areas with any country of the world. In this regard, the court and this network can collaborate to promote judicial cooperation in the areas already mentioned. We can co-host international conferences and focus on common challenges such as constitutional interpretation, human rights, judicial independence, while exchanging knowledge and best practices. Admittedly, our court is limited financially, but it remains open for the forms and scope of collaboration that would not be demanding in that regard. As we saw, the network brings together diverse global and interdisciplinary perspectives. It provides a platform to showcase innovations from both the Global South and the Global North. It fosters collaboration and bridging social, political, legal, economic, and ideological gaps between and within jurisdiction across these regions. This partnership can explore and improve the integration of digital tools. It can address transnational legal challenges and foster cooperation through regional and international networks. Together, the aim is to create a more inclusive and equitable global legal framework. Finally, I would like to express my deepest gratitude to the Right Honourable Lord Reed for his inspiring talk. Again, I thank Dr. Reayat for his dedicated efforts in promoting judicial cooperation and bridging the gaps between the global North and South. I look forward to continued collaboration and engagement in the future through similar initiatives. Thank you very much.
Thank you very much, Honourable Judge Yuan, the Constitutional Court of Bosnia and Herzegovina, and I warmly welcome your recommendation of establishing a permanent group within the Global South involving judges of superior courts of different countries. Now I invite Honourable Justice Alex Steen, the Supreme Court of Israel.
Thank you very much. I think this is a great initiative, and thank you so much for letting me to be a part of it. First of all, I want to thank Lord Reed for his talk. It was very insightful. I also want to mention in this connection that our court has a lasting relationship with the British House of Lords as of 1996, and that subsequently was renamed into the Supreme Court of the United Kingdom. The last visit of British justices took place back in 2019. I was part of that initiative, part of that discussion. I also had the privilege of participating back in the year 2000 when a different delegation of British justices came over. Back then I was a law professor, and so I was invited to lecture, and I still have a fond memory of this event. Our legal system is based predominantly on English law, which we inherited back in 1948. We do have a pretty strong influence coming from other common law jurisdictions such as United States, Canada, to some extent Australia as well. We do have a certain continental impact on our civil side in terms of codification of our private law, but that impact wasn't that significant, remarkably, even though we do have a statutory regulation of virtually all areas of private law. The British and /American, Anglo-American influence is very, very strong. And so our decisions are influenced by British and American jurisprudence and scholarship. In my short remarks, what I want to mention is, first of all, I hope that the last developments that I'm pretty sure you know about in the Middle East will bring, in the end, lasting peace to this region, which will enable us to enhance our cooperation with courts of many, many countries. We do have with some, and hopefully we'll have with many. And so I pray for the lasting peace that will eventually bring up this development. And in my brief remarks, what I want to mention is something that I think many courts nowadays in contemporary democracies have to struggle with, and that's the effect of populism and populist movements upon judiciary. So what I mean by this, I think every one of you knows what populist movements and populism mean, yet it has different forms in different cultures and different countries, but the common denominator is affecting judiciary and what we do as judges and justices is that there is a demand, sort of pressure placed upon the judiciary to make decisions according to some sort of a popular will, which doesn't align with the protections that we all want to give to fundamental human rights and the rule of law in general. And as a consequence, we do have a struggle. And that struggle, is not easy to carry out, given that, courts in Israel, as pretty much elsewhere, we don't have a sword or we don't have a purse. Okay, so all we have is to write recent decisions in the hopes that people will somehow become persuaded. So our tool is persuasion. So we don't have any power in terms of that will allow us to impose financial pressures or other pressures. And for that reason, I think this is a pretty significant challenge. And I look into other countries and occasionally I read about it. And so this is something that worries me. And I hope that this cooperation that has been established will somehow address this issue and from different angles and see how it plays out in different countries and see what can be done to enhance the rule of law, the independence of the judiciary, and the protection of human rights that we all strive to have. Thank you so much.
Thank you, Honourable Justice the Supreme Court of Israel, for your response. Now I invite our Honourable guest speaker, Lord Reed, President of the UK Supreme Court, to respond to online responses.
Well, it's been extremely stimulating for me to take part in this wonderful gathering of judges from around the world. It's a rare opportunity and it's a wonderful initiative by the University of Leicester. I should say that I gave you an edited version of the lecture that I had prepared so as to keep to the time. A full version will be posted online by the university and also by the UK Supreme Court. I'm not going to respond to all the remarks that have been made, but I will respond to a few. First of all, can I thank our Malaysian colleague for being at her desk so late at night. That was really above and beyond the call of duty. Malaysia is a country with which we have an especially close relationship because so many Malaysian lawyers train at our Inns of Court. And it's a country where I had the pleasure of visiting the courts a few years ago when I gave the Sultan Azlan Shah lecture. I very much welcome a closer relationship with the Malaysian High Court. Our colleague from the Maldives, I think, made a very important point when she said that countries from the global north contributing to judicial capacity capacity building compensated for an inequilibrium in resources. I think that's a fair point. Countries such as the UK have a well-resourced judiciary by international standards. We're lucky in having a very good judicial college and in having some time to take our heads up, as it were, from the immediate burden of the cases we hear, to reflect about what we're doing. And I feel that we have a moral obligation to assist judges elsewhere in the world who are less well-resourced than we are, so far as we can. In response to our colleague from Mauritius, I'm very interested in what he said about costs being a barrier to access to justice in the JCPC, and I will follow that up. He made a point which was also made by the Chief Justice of Kenya about the security of judges being an issue. I very much agree. I quite often meet judges who face danger in one form or another. I've encountered judges who need to have a bodyguard. I've encountered a judge in a South American country who couldn't go out in public because of the risk of assassination. I've encountered a particular problem in some South American countries where, in order to increase the diversity of the judiciary and get women onto the bench, they invited quite young female professors to become very senior judges. And they're now finding themselves and their families under physical threat. It makes it's important for them, I think, to know that they have the support of other judges elsewhere in the world to support their morale. And it also works the other way around. I mean, we occasionally here have to decide cases where we know we're going to face criticism from politicians and in the media if we decide the case in the way we think is right. But when you think of the risks that other judges are facing elsewhere in the world, it's really nothing to worry about. And it can be our populations that are at risk, and judges who have a very important role in maintaining the stability of their society. One of the most moving places that I've visited a number of times now is Sarajevo. You can stand there in the Jewish cemetery, which is on a hill overlooking the town, and you are where snipers were based during the conflict, shooting at virtually point-blank range civilians who were trying to fetch food and water, or visit the tunnel by the airport through which people tried to get out of Sarajevo when it was under siege and get assistance. But you can also, in the same city, visit what's called New Sarajevo, where there are schools and squares named in honor of people like Milosevic and Kyrgyzstan, who were convicted of war crimes. So it remains rather as Northern Ireland was until recently in this country, a divided community where the Constitutional Court has a critical role in maintaining its stability, and they deserve all the support that we can possibly give them. In response to our Ethiopian colleague, I would very much welcome further exchanges with his court, as he suggested. We have had exchanges in the past. I remember meeting his predecessor and having lunch with her, in fact, in London just a few years ago, and further meetings would be very welcome. In response to our Greek colleague, he mentioned the importance of exchanges in the form of spending a week or two at a foreign court. This is something I had experience of myself about probably more than 20 years ago now, when I spent a couple of weeks at the Supreme French Criminal Court, and I can recommend that sort of experience. It's a wonderful way of getting a real insight into the way another legal system operates, which you can't obtain simply from books or from a brief bilateral meeting. Our colleague from Ukraine's contribution reminded me of a number of things. I mentioned that I took part online in a conference of Ukrainian judges. That conference had to be postponed, but it was supposed to take place because of a missile attack, and I took part in it on the postponed occasion. The judges from Ukraine whom I've met have the president of his court. I've met now a number of times in Brno and Vienna and Athens. They come there by car and then they drive back into the war zone after our meeting. Some of them I know have managed to arrange for their children to leave the country and be educated elsewhere for their safety. But they and their wives or husbands continue to work in Kiev in a situation of great danger. When I was in Athens with the president of the Supreme Court of Ukraine in September, one of the judges of his court was killed by a missile attack while we were there. These are brave men and women who deserve our admiration. I'm struck. I mean, frankly, one of the most valuable aspects of international meetings from the perspective of a judge like me, who leads a very fortunate life in a stable country where judicial independence is respected, is being reminded of the importance of these values and of the courage that can be required to live up to them. These colleagues are an example to us. They may see us sometimes as an example of how to do the technicalities of the job well. I see many of them as an example of how to get the fundamentals right. Thank you.
Thank you very much, Honourable Lord Reed and President of the UK Supreme Court, for responding to the online responses. Now I open the floor to question and answer session. Any questions, please feel free.
I was just wondering what the perspective of the GSN network was on the universality principle within international law. The aim of the network is to improve and develop judicial cooperation between the global north and the south. And I was just wondering what role you think the universality principle has in that, in terms of beating cybercrime, which was mentioned, and just international crime syndicates that cross jurisdictions. Like, do you think it is something that might be useful to combat such crimes like these and to develop collaboration, or if you think that it goes against state consent and the consent of judiciaries too much to be an asset?
So probably the question is for me, I think.
Yes.
So regarding universality, I mean, I think it's a very good opportunity to explain what I couldn't explain in the beginning because of the shortage of time. If you go to our website, like I said, you know, there are regional focuses and then there are disciplinary focuses. Within the law, we do focus on international law, torts law, constitutional law, you know, the legal skills and methods. If you go to our YouTube channel, there are around 72 videos, each video 1 hour, and 1 hour consisting of experts from across the world, not only from the UK. And very diverse panel, by the way, in terms of gender, color, race, religion. And that's, I think, the best thing about the Global South Network. You name any religion, you will find the person. I think if you go to the last 10 videos, even a rabbi, you will see there, and he will appear, and I think I admire his contribution. Probably he might not be aware of the English language, but still that slides and everything he is able to learn. So universality concept is completely visible in there. And all those sessions, There are a lot of sessions focusing on the cybercrime, the artificial intelligence, intellectual property. We do focus on that. If you go to that page, every section has its own page, has its own team, and every activity, there are different activities. Recording of those activities have been uploaded there. So every section and its team focuses on that particular area within the law and across the disciplines. So it's very much, some people within particular disciplines, for example, law people complain, there's nothing about politics, there's nothing about sociology, anthropology. I think it's completely wrong. If you look at pay attention to the Global South Network, I never mentioned it is Global South Law Network. I never mentioned it as Global South Political Network. The reason being that that's our main aim. The aim is simple and it's written in bold letters on our website, empowering people from or focusing on the Global South through knowledge exchange and sharing good practices. And it's across disciplines. And that is something we want to contribute to groups and associations like the Judges Association, Commonwealth Magistrate Association, European Constitutional Court Association, Islamic Constitutional Court Association, that these associations, like rightly said by Judge Mirza, that are exclusively, not completely exclusively, but more, predominantly they focus on the judges to judges cooperation. So that is what we can really add, and we do hope, we are looking forward to add to that in order to create bridge between the judges and the policymakers, civil society actors. Civil society actor means the journalists, the heterogeneous groups of society, the journalists, the academia, the students, scholars, and professionals. And I think that's all I have got to say. Any other questions? Well,
yeah, I was very interested in something which the Honourable Justice here said from the Maldives. She said that the opportunities to cooperate were endless, I think was the word that she used. Because they are so endless, how do you prioritise those key bits when there's so much pressure on judicial time, I'm sure across all these jurisdictions? How do you prioritise a particular issue?
Well, we have limited resources. Our budget for international relations is £40,000 a year. That's not a great deal of money. Doesn't pay for terribly many flights. We draw up a strategy. We discuss it, in fact, at regular meetings with the Royal Courts of Justice, which is the these matters are dealt with for the Courts of England and Wales. And we broadly divide responsibility between us. We obviously have a particular interest in the Supreme Court in the Privy Council jurisdictions. But apart from that, we effectively leave Wales, that we deal with Canada and Australia. But we leave the rest of the Commonwealth essentially to the Royal Courts of Justice, who are better resourced than we are and can afford to fly people to Nairobi and Johannesburg and so forth when we can't. We focus more on Europe. And we also organise, when it's a matter of meetings where we're representing the UK as a whole, for example, if we're having meetings with the European Court of Human Rights, where it's the UK rather than England that's the relevant party, then we will organise that and invite the English, Scottish and Northern Irish judiciaries to send representatives. So really the bulk of the work is done by the England and Wales judiciary. That's where the judicial office is situated. And if foreign delegations are interested in training, that's where I send them. Whereas we, as I say, have a more limited budget and we focus really on JCPC and Europe.
Any other questions? Shall we start from the one? back. Yeah, please go ahead.
First, I'd like to thank the speaker and Reed and organizing of this very interesting seminar. My area question, I come from a country that's been ruled by the dictator more than 42 years. We went through the Arab Spring. But after 14 years now, we have two governments, one parliament that is extending more than 10 years, and a case now in the country for someone who killed 1,200 prisoners of conscience. The tribes and politicians trying to release them. And imagine that happening in this world now. My question is, the Honourable Speaker and the global network as well, is there any collaboration to help these countries to improve their application of law and order in every aspect? That would be useful. Thank you very much.
Thank you for the question. Before we could respond, can you please specify which country it is?
I think it's very from some. It's in Libya.
Libya, that's right. I think the Global South Network, when it comes to these kind of issues, we are very much looking forward to collaborating with Supreme Court of Libya and the higher judiciary. And the same we want to do with that, with other countries when it comes to Libya, Sudan, Jordan, Lebanon. Because we do think that it's important to know the perspectives. The only challenge we come across is that when we try to highlight one perspective, and just like the Honourable Judge Alex Team rightly mentioned, judicial populism, and all people like start clapping, yeah, well done, it's a very good thing you're doing, fantastic, we support you. And then you try to bring the other perspective, then they start condemning you, that they start feeling like, you're betraying us because we are kind of a traitor or what. I will give you a very simple example. In May, we organized the President Supreme Constitutional Court Palestine guest lecture. Everybody was saying, fantastic, it's a very good thing you're doing. I was receiving a lot of emails, congratulations emails. But when we brought the next guest lecture was of Justice Lutheran in the Supreme Court of Israel, and everything changed. It's very difficult to understand that why it would be a problem to start with Palestine and end at Israel. Especially for the network, we do not take sides. Let this be very clear. We're not going to say like, this government is good, this government is right, because let's be very clear, let's be very practical. If you have grievances against somebody, the first thing you need to do is to engage with that entity. And when you engage, the best possible way is to talk and negotiate. And that is exactly you did in the last week, whatever is happening in the Middle East. After months and months of fighting, you would ultimately, sat around the table, talked, and only then you achieved. And that is exactly what we are going to do. We talked about Libya, give us some time, and hopefully we will come up with something. Any other questions? Okay, please.
Question for the Honourable Reed. From that perspective, what steps can the young professional and international students for those in this country can take the promoting the democracy, enhancing the welfare, and combating the corruption in developing countries.
Yeah. Well, I don't think I have any special authority to answer your question. I think you probably can answer it as well as I can. All one can do is behave well oneself and encourage other people to behave well. It's very difficult where there is a culture of corruption. And for example, there are many countries where there is a problem of corruption in the judiciary. It's a problem that's been raised at the meetings that we have had with the judges of another country. I won't embarrass them by naming the country, but they were quite frank about the problem. And what we discussed with them were a number of things. One was ways of trying to inculcate better behavior, trying to make people understand better what was acceptable and what wasn't acceptable. And for example, take a simple example, the judge accepting a lift to work from the prosecutor who was going to be appearing before him that day. Not a good idea, but people wondered what's the matter with it. I remember being asked at a meeting with judges from a particular country, what sort of watch did I wear? And you see, Air Centre, it was some of the Air Centre who was organising this discussion. And she asked the native judge, what sort of watch do you wear? And I forget if it was a Rolex or an Omega. And then asked me, what sort of watch do you wear? And I said, well, I wear a very ordinary watch. It's about 50 years old. It was my father's. What sort of car do you drive? And the native judge had an S-Class Mercedes. What sort of car do I drive? And it was a 10-year-old Volvo. And she was trying to get over the message that the UK is a country where prestige doesn't depend on material possessions. And if you're a judge in a relatively poor country, where the only way of getting a Mercedes S-Class or a Rolex watch is to take bribes, then you need to change your ideas about what's important in life and see that possessing the Mercedes or the Rolex isn't really what being a judge is supposed to be about at all. So part of it, as I say, was trying to inculcate better behaviours and a bit of a change of culture. The other aspect of it that we went into with this country was looking in much more detail at how judges are appointed and what mechanisms exist for discipline and removal. And that has resulted in changes in that country and indeed in the arrest of some judges who previously, I think, would have felt their positions were secure. So, I mean, there are things that can be done. They need I mean, we're not, it's rather like the question about Libya. We're not in a position to strong-arm people. They have to be willing to change and wanting to change, and we can then give them advice about how to go about it. But if there isn't that, then I'm afraid if you're on your own in your country and these behaviours are going on, all you can do is be a good example yourself and hope to encourage other people to behave better.
I think they was and no. Okay, let's start with the one who is sitting at the back, and then we'll go to the online, and then we'll come back to you, Ed. Go ahead, please. Please try to be very brief. Okay. Yeah.
Okay. Yeah. Okay. Hello. I just wanted to thank you today for the insightful event as well. And moving on to my question, I was wondering, how do you think AI will transform the future of law and transportation, and what steps can be taken to ensure countries with fewer resources are not left behind in its adoption?
Yeah. Someone has a similar question. You can also add to this question. Right. Get back to you separate.
I think that's a very good question. On the first part of the question, I think AI offers many opportunities. It also presents risks. The challenge is to make the most of the opportunities while minimizing the risks. The opportunity, I think, is above all to improve access to justice by essentially making it cheaper to get access to justice. AI ought to make the process much more efficient, and it ought to reduce costs. But there are certainly risks. There are risks even in a country like this. You may know the EU has recently adopted an Artificial Intelligence Act, which is designed to, well, it prohibits the use of AI in areas of the highest risk. For example, criminal sentencing. If you are being asked to use a risk assessment, a tool which will assess the risk of re-offending, and you have no way of knowing how it operates, and you're just asked to take it on trust. That sort of thing is forbidden by the EU Act, which I think is a good idea, and I hope we would do the same. As I say, there are many other ways it can be used very well. I think that is a real problem for developing countries in getting equal access to it. It should reduce costs in the long term, but the upfront costs of acquiring it is going to be high. It's dominated by a handful of corporations, mostly in the United States. It's something which, in fact, when we discussed it at the J20 in Brazil, concern was expressed by the Chief Justice of South Africa about this very point, about how, on their resources, would they be able to make it available generally to their judges. So there is a problem there. One has to hope that it will become like the IT that, like mobile phones, which are very expensive when they were first invented, but now everybody has one. So it remains to be seen. At the moment, it's certainly a problem. I mean, just today I'm dealing with a problem because we have a service that provides us with press cuttings every day. It's not literally cuttings; it's a summary of news stories, so that we can identify at a glance which stories concern us and find out what they're saying. But it's completely inaccurate because they're using some sort of chat bot to the agency, they're using some sort of chat bot to produce the summaries, and it's a piece of nonsense. You probably know that there are lawyers who've been getting into trouble for putting in arguments in court which refer to non-existent cases. I mean, the machine seems to want to please you. And so if you have a case in court, it can't find a real case that supports your argument, it will just invent one. And we've had to consider whether to introduce rules of court about this, so the kinds that have been introduced from Canadian provinces. I haven't done so far on the basis that
a lawyer has a responsibility in any event for the accuracy of what they're putting in front of the court. It needs a special rule for AI. So anyway, I think it has potential to be a great boon. I think the upside possibilities outweigh the downside risks, but we do need to be careful about the risks.
Okay, next. Thank you very much. My question relates to perceptions about the legitimacy of the courts, even in this jurisdiction, against the backdrop of pressures on them, the tabloid media, misinformation that like you just referred to, I think. Now, in your very interesting presentation, thank you for which you referred to, well, I would refer to it as a press unit established, perhaps, within the context of the UniversityofLeicester Supreme Court. And I think the same has been done at the European Court of Human Rights. I just wanted to invite you to comment upon that a little bit more, if you're able to do so, and what the driving forces are. I'm assuming, I may be wrong, that this comes against the backdrop of misinformation, poor reporting of certain judicial decisions, and efforts to correct that. The bigger issue being that the perceptions of the legitimacy of the judiciary are absolutely crucial for their acceptance in society generally. Thank you.
Yes, thank you. You're absolutely right. Trust is vital to our role. And there is interesting evidence in the form of an opinion poll that was done for this Economist magazine not very long ago, which showed that amongst people who said that they knew a fair amount about the Supreme Court, the proportion who said they had a high degree of confidence that it would do its job well was 84%. So amongst people who know about us, it's a very high level of confidence. Amongst the people who said that they didn't know much about the court, the level of confidence was 52%. It's still, actually by European standards, 52% is a high figure, but it's nowhere near 84. So it's clear that essentially the more people know about us, the higher the level of confidence they have. So that's really, that thinking that underpins our effort to improve public understanding. It takes a number of forms. We have an education team, we have an outreach team, but the communications team deal particularly with the media. They identify journalists who regularly cover the court. They allow those journalists to see most of our judgments on an embargo basis the day before the judgment is handed down. And they will answer the journalists' questions about the judgment. And the idea is that that enables the journalists instantly to give accurate reporting when the judgment is delivered. Now, we don't do that in cases where the temptation to break the embargo would be too good to resist. And in those cases, we take particular care. In every case when we hand down judgment, we go publicly, and we issue the judgment itself online. But to camera, one of the judges will give a short explanation in ordinary language of what the court has decided and why. And in a case of media interest, we take particular care over that. So, to give you an example, when we handed down the Rwanda judgment, which I had written, I did the hand down. I took advice, I drafted what I was going to say, but I then ran it past our comms people to see if they had any comments on my language, because what I might think is ordinary language that anyone would understand isn't necessarily completely accurate. So they came back with 1 or 2 cases where they said, you know, you could make that perhaps a bit simpler. They also impress on me the fact that while what I say is going to be carried on the BBC News, the ITN News, they'll only play a clip of maybe 10 seconds, 15 seconds. So you want to try to find a sentence which encapsulates what you want to say. So that's sort of, I mean, frankly, left to my own devices, I don't know if I would have thought of that. So having a professional comms team can be very useful in giving you advice. It's not about spin, it's about how to communicate so that we explain to the interested member of the public what we're doing and why. And I think it's made the reporting of our cases has become much more accurate than it used to be. And I think it's largely down to these efforts that we're making to help journalists, because once upon a time you could expect them to take the time to read what you'd said and produce their own report of it. But the time pressures on them are now such that it's really much more likely that you'll get an accurate report if you feed it to them yourself.
Thank you. One last question. Please try to be brief. This is going to be the last question.
Thank you for the opportunity. My name is Brian. And my question is, I'm from the Global South, and I've heard that there's a lot of support that comes from the United Kingdom to that part of the world. So I'm thinking, in what way has the United Kingdom borrowed from the Global South to enrich its judicial system, because it's a collaborative effort?
I think I would need a little time to give you a list. I'll tell you the very first thing that comes into my mind, because as my wife would say, I'm a rather sad man who's obsessed with law. And the first thing that came into my mind is that we had a case recently from the Caribbean about the relationship between arbitration and insolvency procedure. And we decided, and the Caribbean court had refused to follow an English precedent in the Court of Appeal. And indeed, the English precedent had itself already been followed by the courts in Singapore and I think Australia. Anyway, we looked at it. We thought the Caribbean court was right. And this is a JCPC case. So we exercised the power that we have when we give judgment in a JCPC case to say that it's also going to be a binding authority for the UK. So that's a case where a judgment by a court in the Caribbean has influenced us, and it's now the law for the UK. I wouldn't be surprised if it's followed now by other countries around the world. That's if you like, that's a trivial example, but that kind of influence is by no means unknown. If I look at it more widely, the examples I was speaking a moment ago about the admiration that I have for the courage of judges who are doing their job under far more difficult circumstances than I am. That's the big influence on me. When we decide a case like the Rwanda case, I think to myself, well, I may be in for a hard time in tomorrow's newspapers. That's the worst I have to worry about. Some of these judges have to worry about their lives, or their children's lives, or their wife's life.
So they're an inspiration to me. I don't have to say a lot more if I thought about it, but there you are. They can be a legal influence and they can also be a moral inspiration.
Thank you very much for the questions, and thank you very much, Honourable Reed, President of the Supreme Court, for your answers. Now, I would like to conclude the session. I will not take a lot of your time because it's already very late. But I must say, I mean, I'm really grateful to all judges from Malaysia, Kyrgyz Republic, Maldives, Mauritius, Supreme Court of Kenya, Supreme Court of Ethiopia, Atlantic Council of State Greece, Supreme Court of Ukraine, Constitutional Court of South Africa, Constitutional Court of Bosnia and Herzegovina, for saving their time and ensuring their availability at such late time with huge time difference. I think I will build upon the point which Justice Alex Dean mentioned, and that was the judicial populism. I completely agree with him that judicial populism is a huge threat for countries, especially in the global south, as well as in the global north, when it comes to even countries like US Supreme Court and Israeli Supreme Court. And what is, I mean, I think for the people law background, it's very difficult. It's a bit difficult to understand what is judicial populism. Judicial populism, in simple word, means that making a decision in light of public opinion, and public opinion influencing your decision making within the court. That is the simplest meaning. I mean, I'm not saying that it is not a contested concept. It is a contested concept, but in layman terms, for general public, that's the best I can come up with. How to avoid that? I think the best way to avoid that is we do not need to get influenced by public opinion, but at least we need to understand what is public. And it's because ultimately the decisions and the rulings you deliver has implications for society. We accept it or we do not accept it, it has implications. Secondly, society is not something static. 90s British is completely different from 2024 British. And same goes for all other countries. There's a class mobilization, there's a social change, and all, people who are at helm of affairs, elites, including judicial elites, they do need to understand who is public and the heterogeneous groups of society that constitute public at large. But how to do that, I think, that's where the Global South Network comes in. It gives you that opening to different groups of society, different disciplines, different regions, and offer services that can contribute to bridging gaps between different regions of the world and different professions. Having this said, I think it's time to follow up on this activity, how to take this further, the activity which we have. I don't think that the way we do things in Global South Network, it's a one-off affair. As a follow-up, we do plan to, I think we already have discussed, just, to some extent, the possibility of coming up, to publish an narrative collection on similar theme, identifying different areas of judicial cooperation with the cooperation of judges of different countries, most of whom have already delivered their responses in today's event. And also considering a recommendation from Honourable Judge Mirsad Kemal, the Supreme Constitutional Court of Bosnia and Herzegovina, establishment of a permanent group. I think it's a brilliant idea. I do agree with that, and I think the next step I'm going to do is to reach out all courts, and it's to give us one focal person, one judge. It could be one judge, anyone who can be as a member of that advisory body within this group, and advise us on different action points and the next steps we can take in collaboration with actors outside judiciary in these countries. Thank you very much for coming. Thank you all who are online for attending the session and delivering the responses. Thank you very much. Look after yourself. Have a great day.